Hi everyone, welcome to paper analysis. Today is 27th of May and this is the video for the day. So let's start with the quick pointers of discussion for today. See, please note, first of all, in the editorial segment, we'll have a topic to discuss from the Indian Express. The title of this article is, Can a Judge Have Political Affiliations? In this article, essentially, we'll understand, what is the position in India so far as judges having political affiliations is concerned. Then we'll talk about the situation prevalent in UK by the USA. Secondly, we talk about the news updates for the day, and this is going to be followed by the last segment of legal news. So without further ado, let's start with the article. Let's first have a look at the title of it. Can a judge have political affiliations? So quickly, let's have a look at the context as to how this topic has come to the forefront. So please understand, on 20th of May, which was Monday, a judge of the Calcutta High Court took retirement and he was giving his farewell speech. While doing so, he mentioned about his membership of the RSS, which is the Rashtriya Swam Seva Sangh. So he stated in a farewell speech, and I would like to read it out. He stated, "Today I must unfold my true self. To the detest of some persons, I must admit here that I was and I am a member of the Rashtriya Swam Seva Sangh." This was stated by Honorable Justice Chitta Ranjan Das, now retired judge of the Honorable High Court of Calcutta. So when he said this, now there is a conversation about whether judges can have political affiliations. Article. Now, please understand this is an opinion piece, but for our purpose, we'll just try to stick to getting knowledge about the legalities of it. How are judges appointed in our country? Did we ever have a situation where we could clearly see that judges have political affiliations, so on and so forth? So that is going to be the core of discussion for today. So at the outset, let's understand how are judges appointed. That we'll see here. But first, let me just give you a brief picture of did we notice a shift of judges having affiliations? So for that, the author in this article has given a reference to a book which is written by an advocate and a legal scholar. His name is Abhinav Chandrachud. So he wrote a book by the name of Supreme Whispers, Conversations with Judges of the Supreme Court of India between 1980s and 1989. So he stated in his book that prior to 1970s, a judicial candidate's political ideology, it was not much of a concern in the judicial appointments process. So before the 70s, this was not a concern, but we saw a change. We saw a shift later in the later half of 1970s during the tenure of Indira Gandhi's government. So this changed after Indira Gandhi's government suffered setbacks in the Supreme Court in a series of judgments. So let's say we saw the judgment of Golaknath, which goes back to 1967, then followed by bank nationalization. Then we also had the judgment of Privy Purse's case. So basically, what had happened, what was happening this time was in the late 1960s and the early 70s, we saw so many landmark judgments which interpreted the constitution, and there was so much back and forth, with the 24th Amendment, the 42nd Amendment, 44th Amendment, all of these, happening. It was almost like a back and forth between the judiciary and the government. So, for instance, in the case of Golaknath, the Supreme Court categorically held that, you cannot amend the fundamental rights. These are very sacrosanct portion of the Indian Constitution. And in order for the government to amend the fundamental, to literally convene another constituent assembly, you could not do so with your power under with the procedure under Article 368 of the Indian Constitution, because the power of amendment is not given there. And then eventually the article marginal head of it was changed to power and procedure of amendment. So that's a separate thing. But what I'm trying to put forth here is, please understand, during this time there were a lot of judgments which were anti-government, so to say, because government at that point in time was trying to amend the constitution to a great bring in, let's say, agrarian reforms, and thereby right to property, which was a fundamental right back then, it was curtailed to a great extent. So the judiciary, in the case of Golaknath, said that no, you cannot do that. So that was also a setback for the government. So then the government realized that it is important for us to have a judge who is aligning with our ideology. And that was in fact said by a cabinet minister in the government of Indira Gandhi. He said that he openly advocated the doctrine that the ideology of judges it considered by determining whether they were fit for appointment to the Supreme Court or not. So there was a time, this was a time when we, sort of saw a shift. Now let's understand how are judges appointed in our country. So this is important. Here it is just mentioned that since 1990s, appointments to the Supreme Court and the High Courts, they've been done through the collegium system in which judges appoint judges. And there is a presumption of neutrality of judges in India today. And the judges are not usually, expected to have any overt political affiliations. Now, since we've talked about the appointment of judges, so let's briefly, talk about it. So if you open your Beret, you will see that there must be a mention of NJAC, that, the appointments must be done by the president in consultation with the National Judicial Appointment Commission. But that is, if you have a look at the footnote of it, you will see something else. So let me tell you the position which is written in the Constitution and the position that we follow today because of the 3-4 case laws that. So in the Constitution, what is mentioned about appointment of the CJI is that the president has to make the appointment, but he may consult any judges of the Supreme Court or the High Court as he may deem fit. When it comes to the appointment of Supreme Court judges, it is said that the president can consult Supreme Court judges, High Court judges as he deems fit, but it is, the CJI should always be consulted. This is what is, written in the Constitution. Now, there were a series of case laws. The first judges appointment case, second and third, and followed by fourth. So in the first case, which is the case of S.P. Gupta, therein the Supreme Court was faced with the question whether this word consultation of the CJI, does it mean concurrence? Is the consultation of the CJI binding upon the government? So the case of S.P. Gupta was pro-government, pro-executive. It said that consultation is not equivalent to concurrence. The president has to consult, and let's say the CJI is saying that, appoint XYZ as the judge of the Supreme Court. If the president, given the aid and advice by the Council of Ministers, does not want to do so, then he's free to, not be bound by the advice or recommendation of the CJI. But this switched in 1993 when we saw the second judge's case. In that case, essentially, the Supreme Court held that consultation is equivalent to concurrence. The judgment, the opinion which is given by the CJI, the recommendation, it has to be, followed. It is bound upon the executive, the president. And it was also said that the CJI to give his opinion solely, entirely upon his own volition, is going to consult two senior-most judges of the Supreme Court. So hence the idea of collision was formed in the second judge's case. Then it was more refined in the third judge's case in the year 93 or 98, wherein it was said that the CJI has to consult plurality of judges. By plurality, we mean CJI has to consult 4 judges of the Supreme Court, 4 senior-most judges of the Supreme Court, to give recommendation to the president so far as appointment of Supreme Court judges is concerned, and the transfer of High Court judges are concerned. So currently, this is what we follow. The collegium of the Supreme Court, constituted by the CJI and 4 most senior-most judges of the Supreme Court, they give recommendation to the Law Ministry. It goes there, and then eventually it is, given and conveyed to the president, who makes the appointment. So if a question comes as to who makes the appointment, then the answer would be president. But it is made on the consultation of the collegium. So hence the system of collegium that we have. Then in 2014, 99th Amendment came about, which changed the procedure, and it said that, appointment would be made by a commission, which is going to have the representatives of the government as well. So that was again overturned by the judiciary, and it was held to be unconstitutional in the 4th judge's case, which I believe goes back to either 2015 or 2014. So this is the entire procedure of appointment of judges. Now let's understand. So far as the position of political affiliation is concerned, currently this is what we look at so far as India is concerned, that judges in our country, they're not pro-government, not anti-government. They just are governed by the fundamental law of the land, which is the Constitution of India. However, there were others, including lawyers, who argued that the BJP was not a banned entity and that it was the judge's conduct after elevation that mattered, not opinion that she may have expressed earlier. So this is just, an argument in the piece of an opinion. We'll just skip this and let's just have a look at what is the position so far as UK is concerned. Unlike the US, we'll have a look at the position in US in just a bit. Judges in the United Kingdom, they are selected by a process that prioritizes merit and experience over political affiliation. The system, it relies on senior members of the judiciary and others who are acquainted with the judiciary to choose judges whose selection must be on merit. So they follow merit and experience and not political affiliation. In fact, UK Guide to Judicial Conduct, it categorically states, and I would like to quote it out, any judicial office holder who is known to have strong view on topics which is relevant to a case by reason of public statements or other expression of opinion should consider whether it would be appropriate to hear the case irrespective of whether the matter is raised by the party. The risk will arise if a judicial officer has taken part publicly in controversial or political discussions. So let's say there is a matter which is going on before the court about, let's say, homosexual marriage. And if we know that there is a judge who has had certain opinions expressed in the public in the past. So in fact, their manual in the UK categorically states that judge should himself consider whether he should be hearing this case or not, because he is known in the public domain to have had a certain opinion with respect to that topic. So regardless of whether the party raises an objection or not, it is the duty of the judicial officer self see whether he should hear this case or not. Judges in the UK, they are expected to avoid any appearance of political ties. For example, by attending political gatherings, political fundraising events, contributing to political parties, or speaking at political forums. They are also expected to not participate in public demonstration which would associate them with a political cause, diminish their authority, and cast doubt on their independence. Judges, they are also prohibited from Parliament under the House of Commons Disqualification Act of 1975. So clearly we can see in UK, they do not follow political affiliations. They discourage it and they follow merit and experience. Now let's see what is the position in US. So please understand the position here is quite different. It is quite contrary. So the American system places judicial appointments in the hands of politicians themselves. So the president appoints judges to the higher judiciary. Appointments are confirmed by the United States Senate in what is most often a partisan vote. US judges, they serve for life, and they have also just like, for instance, in our case, the Supreme Court judges can hold office till the age of 65, or, if they are removed before, then that's a separate thing under Article 124. But if they are not removed, then they serve till the age of 65. But in the US, they serve for life, and they have well-known positions that may be conservative or liberals. So the judiciary is very clearly divided. The judges can either be conservative or they're liberal, and it can be very clearly seen in their judgments as well. A conservative or a liberal majority in the 9-judge Supreme Court often means that the outcome of at least some cases can be predicted with a degree of certainty. The appointment of 3 consecutive judges, conservative judges, by President Donald Trump has resulted in 6 conservative super majority in the Supreme Court of US. So therefore, we can clearly see whether the judgment on any particular topic would come for or against, depending on the ideology that the political party has with respect to that topic. However, Canon 5C of the American Bar Association Model Code of Judicial Conduct 1990, it prohibits judges from engaging in political activity except on behalf of measures to improve the law, legal and the administration of justice. Further, for Canon 4 of 2007 Model Code, it provides that a judge shall not engage in political activity that is inconsistent with the independence, integrity, and impartiality of the judiciary. It does not include an express exception for political activity related to the administration of justice. The document says that giving the appearance of continuing ties by attending political gatherings, politicizing events, or through contributions to political parties should be avoided. The court further says if a judge is known to hold strong view on topics relevant to issues in the case because of public statements or other expressions of opinion, the possible disqualification of judge may have to be addressed whether or not the matter is raised by the party. So this is somewhat similar to what we saw in the case of US, but in the case of UK, but by and large, it is a known fact that in judicial office is highly political. And with this, now we proceed to the next segment of national news. So this is the first update here. Sachin Khilari defends gold at World Para Athletics. India Sachin Sarzerao Khilari, he wins men's shot put F46. He defends gold medal in men's shot put F46 category, setting Asian record. Dharamveer, apart from him, Dharamveer secures bronze medal in throw F51, bringing India's total medal count to 12. Another update is also in the sports category. Virat Kohli becomes first batter to reach 8,000 runs in IPL history. Indian cricketer Virat Kohli, he has become the first batter in the history of Indian Premier League IPL to score 8,000 runs during the IPL 2024 eliminator between Rajasthan Royals and RCB, which is Royal Challengers Bangalore. This happened on Wednesday. India registers positive growth among top 5 world steel producers in the month of April. India is the only country among the world's top 5 crude steel producers to register or record positive growth in April 2024. This is according to the World Steel Association. India, the second largest crude steel producer globally. So this is something that you may make a note of. India currently the second position so far as the crude steel producers are concerned. It achieved a growth rate of 3.9% compared to April 2023. Now, this is an update in the category of important days for the day, and the day concerned is World Football Day 2024. In 2024, the world marks the 100th century of the first international football tournament involving teams from all regions, held on 25th of May 1924 during the Summer Olympics Games in Paris. To honor this milestone on 25th of May in 1924, the United Nations General Assembly passed a resolution which proclaimed May 25 as the World Football Day. Let's understand why 25th, although we've already had a look at it. So 25th of May, chosen to commemorate the centenary, the 100 years of the first international football tournament during the 1924 Paris Summer Olympics. So that has already been stated. Now this has brought us to the international news segment, and this is the first update. International Week of Solidarity with Peoples of non-self-governing territories. The United Nations commemorates International Week of Solidarity with peoples of non-self-governing territories annually from 25th of May to 31st of May. Currently, there are 7 non-self-governing territories left in the world. Established by the United Nations General Assembly on 6th of December way back in 1999, this observance, it highlights the struggles of these territories and it promotes their right to self-determination. Let's understand what is a non-self-governing territory. See, it refers to a territory where its people, they have not yet achieved complete self-government. Next up is an update with respect to Palestine. Ireland, Spain, Norway recognize a Palestinian state. Irish Prime Minister Simon Harris, he announces the recognition of Palestine by Ireland, Norway, and Spain. This recognition will take effect from 28th of May, which is tomorrow. The Norwegian Prime Minister, he emphasizes the necessity of a Palestinian state for Middle East peace. Now, as was expected, Israel has given some response to this update. Israeli Prime Minister Benjamin Netanyahu, he criticized the recognition of a Palestinian state as a reward for terror. The foreign minister also ordered the immediate recall of its ambassadors to Spain, Norway, and Ireland. Next up is an update about 10th World Water Forum opening in Bali, Indonesia. The 10th World Water Forum, themed Water for Shared Prosperity, officially commenced on 21st Bali, Indonesia. Attendees included numerous country leaders and United Nations representatives. Let's talk about World Water Council. So it underlines need for global efforts to repair environmental damage, and it emphasizes unifying power of water. Next up is an update about or from Maldives. Maldives to launch India's Rupay service amid bilateral tensions. First world card payment network is Rupay, run by National Payments Corporation of India, which is the NPCI. It can be used as ATMs, point of sale terminals, and online stores in India. The Maldivian Minister for Economic Development and Trade, he announced that the launch would take place in the Maldives. This project, it is meant to help the Maldivian economy by making the MVR more useful and stable. Next up is an update from UK. So British PM Rishi Sunak, he declared July 4th as the UK general election date. The announcement overturns expectations of an autumn election, potentially allowing Tories to close the gap with Labour. So this is just a political conundrum. For our understanding, what we have to just remember is that the election season is around 4th of July. Tolam, new president of Vietnam. Tolam, Vietnam's former Minister of Public Security, he has been confirmed as the nation's new president by the National Assembly. And now we proceed to the legal news for the day. And the first update comes from the Honorable Supreme Court in the case of Rajendra, son of Ramdas Kohli versus State of Maharashtra. So this is with respect to dying declaration, the topic which is, a subject matter concern of the Indian Evidence Act. So the Supreme Court has held corroboration of the dying declaring statement isn't required when it inspires the confidence of the court to convict the accused. So suppose there is a dying declaration and the dying declaration is absolutely blot free. It is, it is firm. It inspires the confidence of the court and there is no doubt about its trustworthiness. So then in that case, corroboration is not needed. So accordingly, the court noted that there was no reason to doubt the correct declaration of the deceased. So this is with respect to the factual aspects of this case. Let's understand the legalities that the court highlighted. So the court said that the law relating to dying declaration is now well settled. Once a dying declaration is found to be authenticate, to be absolutely credible, trustworthy, authentic, it inspires the confidence of the court, then the same can be relied upon and can be the sole ground for conviction without seeking any corroboration. This is very important. Please remember, here the court is said solely based on the dying declaration, conviction can be sustained. You do not have to call for other pieces of evidence to corroborate this dying declaration. However, the court further added that before accepting such a DD, court must be satisfied that it was rendered voluntarily, and it is consistent, it is credible, and that it is devoid of any tutoring. Once such a conclusion is reached, a great deal of sanctity is attached to the DD, and as said earlier, it can form the sole conviction. So this update is from the Honorable High Court of Delhi. Please note this is a Delhi High Court update. So here the Delhi High Court has observed in the case of VLS Finance Limited versus State Entity of Delhi and others that the right to be heard given to a victim or complainant in a criminal case cannot be uplifted to a right to be impleaded in a criminal. The court further observed that right of the victim to participate in the trial and the proceedings, it is not of a position where the victim replaces the public prosecutor, because we know in criminal cases, state is a party, right? Because we consider that crime is essentially a wrong against the society. And it is in the larger interest of the society that the criminals are, brought to justice. That is to say, the criminal are, subjected to legal process and they are prosecuted, and further they are put to trial, and further, if found guilty, they are. And so here the court has said that the victim's right to participate in the criminal trial and the proceedings, it is not of a position where the victim himself or herself is replacing the public prosecutor. The Delhi High Court further held that the right would remain subordinate to that of the public prosecutor, and therefore, where the victim applies for a hearing in a revision petition, while the victim must be heard, but there is no mandate in law to implead the victim as a party, which we often see that, it happens in civil that the party impleaded. In fact, there is a law that, necessary party impleadment is a must. Otherwise, an effective decree cannot be passed. But in criminal law, so far as that is concerned, we often see that it is usually, so-and-so versus the state or state versus so-and-so. So that's about this case. And this has brought us to the end of our TNA. Thank you so much for being here and have a wonderful day ahead.